Preet Bharara is the former U.S. Attorney for the Southern District of New York, where he led many high-profile prosecutions of white-collar criminals, and he joins me now. Preet, first of all, as you know, I'm not a lawyer. I tried to just summarize what we learned today. There we go. I tried to summarize. I talked to a lot of smart ones. I tried to summarize what we learned today. Did I miss anything? Did I get anything wrong there?
No, it was a pretty good summary. And I think what you heard today was testimony that was not so dramatic, not as dramatic and salacious as some of the testimony we've heard before, and that we are certain to hear in the coming days. But it goes to the core of the basic criminal charge here, which is falsification of business records. And I think, based on what happened today and how uninspiring the cross-examination was, because the documents largely speak for themselves, the prosecution has basically proven the basic case, which is falsification of business records, which people can argue is or is not the crime of the century. It's a misdemeanor. The New York law recognizes it as a misdemeanor, and we can argue and see how the evidence comes in with respect to the next phase, which is whether that can be accelerated into a felony if it was done for the purposes of concealing or furthering some other crime, an election law crime or a tax crime. But the basic fundamental case, the elements of which were laid out, in crystallized form today in court, I think were made out. You have, the representation that these things were legal fees based on a retainer and legal services. You don't have any documentation to that effect. You don't have any detailed business records, as you and I were saying before we started recording today. The bane of the existence of any practicing lawyer, and I'm a practicing lawyer once again, is to do detailed records of how you're spending your time and why the client needs to pay you, what you're charging the client.
And there's no detail of that.
There's zero of that. Literally every lawyer in America has to do that. I've never worked on a matter for any client where there wasn't a formalized agreement and an understanding as to what you get paid for and why. You have none of that here. You also have, as you mentioned, the fact that Michael Cohen was not just paid for the reimbursement. Lawyers all the time, we have photocopying fees, we have binding fees, we have other fees that we have to get reimbursed for. We don't get paid double for that.
Which is his tax rate, by the way.
Yeah, because Michael Cohen stepped up for the team, took a hit for the Donald Trump fraud team, and paid out of his own money based on the home equity line of credit money, the hush money for this person, and that was after taxes. So in order to make him whole, he had to be paid not just the reimbursement amount, but also an amount that was pre-tax would put him in the same position as he was in otherwise. That lawyers, that's not a legal
That's not how it goes
That's not how it works.
with lawyers. It's just important for people to remember. Yeah. What struck me also, non-lawyer again, is the Alan Weisselberg. I mean, they wrote out exactly how this reimbursement would work, which presumably for the prosecution is pretty damning.
It's very strong. It's very strong. And, at some point we'll get into the question, not today necessarily, but how formidable is the testimony of Michael Cohen going to be? And I think the prosecution has done a great job of laying the foundation of corroboration before Michael Cohen testified, because he's going to come up on the stand and say it wasn't legal fees, it wasn't a retainer, it wasn't legal services, it was for this other purpose, which the prosecution alleges was illegal. And rather than corroborating him after the fact, they've corroborated him before the fact. Also, as you and I and others have been talking about for months now, Michael Cohen has some baggage. But every single witness who's testified, who knows Michael Cohen, has been asked a question about Michael Cohen, has, I think, set the bar so low for Michael Cohen that I don't know that he has to do as much as we've all anticipated he needs to do.
Right. He doesn't need to own the totality of it. Let me ask you about the gag order, because, the judge threatened, of course, if he violates it, he could put him in jail. What does that look like? People have been speculating it could be an hour. Is it an hour in jail? Is it something else?
I think it could run the gamut. It's an interesting thing, not for this time necessarily, but the statutory basis in New York, the law is that you can fine for criminal contempt $1,000 per violation. And it might strike some people as odd. It strikes me as a little bit odd, but we're not in the position to change the law at this moment, that the next step after a $1,000 fine is not a $2,000 fine or a $5,000 fine or some other intermediate step. It's separation from your liberty for up to 30 days. So, the judge is between a rock and a hard place. And I thought that what you read before was absolutely stunning. That you have a sitting judge who, I think people understand that a judge in his position doesn't want to put Donald Trump in jail for a period of time, doesn't want to have to be in that position. The interesting thing is he said it. He's very honest about it. He's very forthright about it, which to me means that he's serious about it.
How does he calculate? If you're the judge, though, I mean, if he's sent to jail for an hour, does he really care? I mean, he may get something out of that. That's my theory here. He may want that.
I don't know. We're in uncharted territory. We've never had a former president of the United States who has an actual right to Secret Service protection and a Secret Service detail for the duration of his life, whether he's president or not. In that circumstance, I think nobody wants to, the judge least of all, wants to figure out how we deal with that. So I don't really know. I do think I've only one. I never have any quibbles with you. I have one quibble with you, which is
you can quibble with me anytime. You're the legal expert, not me.
Well, this is not necessarily a legal question. It's a sort of Trump psychology question. I don't think, notwithstanding his bravado and his comparisons of himself to Nelson Mandela or anyone else, he does not want to spend he does not want to spend a night in prison. It's very uncomfortable. There's lots of problems that he would face personally and otherwise, and aesthetically and grooming wise, that I don't think he wants to get into. He likes to talk a good game and say, I'll be a martyr, but I don't think he wants to go. And so it'll be an interesting cat and mouse game.
He may want to go for an hour because he's been fundraising off it. We may agree to disagree.
An hour he can do.
A couple hours.
Standing on his head, as some defendants have said.
Let me ask you. I mean, the trial, they resume tomorrow morning. There's some big witnesses who we've not heard from yet. Yeah. What are you? Michael Cohen is obviously a big one. Who else are you watching for?
I mean, the Stormy Daniels, I think testimony will be interesting. But look, I will say, and I'm at risk of being disabused of this depending on how the testimony goes, I think the most important testimony has already taken place, right? With these witnesses, David Pecker and
was David Pecker the most important one?
In some ways, yes, because he's less assailable than Michael Cohen. He basically told the story of how all of this, all these machinations were important to and relevant to and were for the purpose of winning the election. You have some, holes here. You had Hope Hicks testify in part that obviously, she got some hits for the defense, which the prosecution probably didn't love, saying that, part of the reason Donald Trump engaged in this conduct was he wanted to spare his wife humiliation. That doesn't help to prove the prosecutor's case. But you have all these witnesses talking about the money, talking about the documents, talking about the purpose of the documents, the lack of documentation of this being a retainer and this being legal fees, and then the overwhelming amount of evidence, which is a little more in play than the documentary evidence, but still, I think, overwhelming evidence that this was done close in time to the election because Donald Trump cared about the election more than anything else, and that's why he engaged in this behavior. And these other witnesses will be interesting. We'll talk about them. And the cross, from a sort of lawyerly perspective, is going to be fascinating and a popcorn-eating event. But I don't know that they're going to be as important and seminal given the testimony that's taken place so far.
Preet Bharara, always a pleasure talking to you. You can quibble with me anytime. I welcome the quibble.
Not an argument. We only quibble.
I love a quibble and a debate. Thank you so much for joining me tonight.